It's a, the word just went literally.
21.
Rule against perpetuity. 21 years after the last living beneficiary. So normally the trust will have that language in it, and then it doesn't violate the rule against perpetuities. But if you were to create a trust, let's say at 25 years old, and you live to 100, the bank doesn't have a basis to say this trust is too old because it's been around for 75 years. That just doesn't make any sense to me. But as long as it doesn't violate the rule against perpetuities, it's not an issue. You may have to move your account from that bank to another bank, but that's a different conversation.
Okay. Questions from St. Croix on trust?
If you plan to turn your business into an LLC, would you do that before it goes into a trust or after it's in the trust?
You need to make sure the trust exists. As long as the trust exists, you can, it's 6 of one and half dozen of the other. But the trust has to exist.
Question on St. Thomas?
Yeah, we have a question.
Thank you so much. One question. When it comes to, we had a lot of the attorneys here spoke about contingencies, predeceases you, or you may not know within your network people who might be qualified to carry out these very important tasks. What are some of the tools or options that people can have where the trustees can be competent and could survive the lives of any people that might be in their lives? For example, corporate fiduciaries and things of that nature.
So, managing your trust is a very personal thing because you want it to be somebody who knows you and what you want and what, carry out your wishes. Now, what we normally do is we have contingencies in the sense that we have maybe 3 or 4 successor trustees, and we tend to pick the successors based on who's younger, so that you may be picking somebody who is, the third person might be significantly younger than you are, but somebody that you know. There aren't successor trustees that hold themselves out to do that. There may become an industry for that. I'm not 100% sure that I would be comfortable with an absolute stranger managing your interests. I think you would probably be better served by having a friend or family member, maybe it's an accountant that you work with that maybe it's an accounting firm to manage some of the financial aspects. But you really need to, I've had people literally take a year to decide who their successor trustees are going to be. It's a big responsibility. It is a thankless task. And you want to give them as much information as possible so that they're not running around looking for your assets and trying to figure out what you have. You want to give them as clear a roadmap as possible. But at this stage, I'm not aware of people who hold themselves out as successor trustees, but even if there were, I'm not 100% sure I would just jump on the bandwagon and say, yes, I'll have an absolute stranger make my decisions for me. I'll repeat, yes.
Earlier you mentioned trust bank accounts and trust brokerages. I was curious if you established the trust and then you opened the bank account with the brokerage, or is the trust bank account or trust brokerage
Okay, so the question has to do with brokerage accounts, bank accounts, and whether the account is initially a trust account or something else and then becomes a trust account, right?
Or if the trust account or trust brokerage is separate from being an account opened by the trust. But you mentioned trust bank account, trust brokerage, but it seemed like it was separate from
Okay.
the trust where you would put your property in that trust.
Right. So in most, maybe not all lending institutions, if you have an account already, because of their accounting system and new legislation, a personal account has these numbers, a business account has this series of numbers, and a trust account has this series of numbers. That hasn't always been the case. 9/11 has a lot to do with some of these changes. And so there was a time where you could simply change the name on the account from your personal name to the name of the trust. Most institutions now don't do that. Most of them have their own form, and you would then fill out the forms, and the account would literally be taken from your personal account and moved to a trust account. So then it becomes a trust account. Now, if you can open a trust account. In other words, we're not talking about an account that already exists. We're talking about you creating an account. For the first time, you can open a trust account at an institution, and it'll be designated as that trust account.
But I would need to establish a trust first. That's why I tried to
Absolutely.
get. It wouldn't be me opening an account. It would be the trust opening an account.
You can't-
And that's
you-
what makes it the
right.
trust bank account or trust brokerage, correct?
Right. You
Okay,
have
that's
to
the
have a
clarity.
trust in place before you have anything in the trust. And this is also very critical just about everything. You can't transfer property to a trust that doesn't exist. That's not going to be a valid transfer. If you transfer a piece of property in 2024 to a trust, but the trust doesn't exist until 2026, forget about it. Any other questions in
Okay,
St.
I
Croix
have
or
a-
online?
I have some questions online. One of the questions is pertaining to how to help a successor trustee in financially dealing with the trust. Can you put the money in the trust to deal with administering of the trust?
Yes, so as we were just discussing, a lot of times you end up moving your personal accounts into a trust account, so it now is a trust asset. And when you move your property into that trust account, then the successor trustee has access to those funds to pay your medical bills, to pay for your light, to keep WAPA going and get your gas bill paid and all of those good things. And so that is accomplished through the avenue of having that account in the trust already. If it's not in the trust, the only mechanism that you have is a general power of attorney. But that general power of attorney is only going to be good during your lifetime. And then when you die, so does that power of attorney. And if that asset's not in the trust, it's not in the trust. You're off to probate again.
Okay. One moment. Open a trust for someone if you have their power of attorney?
Possibly. Is the person incapacitated?
Their health, their medical, everything is in there. And you say, well, okay, in their discussion, a trust is the best thing to do. Can you do that on their behalf?
You might, I'm hesitating because you might be able to, but if that person has capacity, your better bet is that they, as the settler, set it up. They sign the document themselves if they have the ability to do that. and they have the capacity to do that, that is the better route because they are the settler and they're not just the power of attorney. Somebody could later on, when they're not happy with what the trust says, say, oh no, that wasn't their wishes, you manipulated the situation as the power of attorney and did something that wasn't their intention. That's why I hesitate. Legally it might be something that could work, but is it foolproof? I would think that it would raise some flags.
We have some questions from Zoom.
Yes.
The first is, can a trust done by a VI husband and wife control disposition of real property in the States?
Yes. That was an easy one. You still have to transfer the property. You do not need more than one trust. Your trust can manage all assets anywhere on the planet. You just want to transfer those deeds from you to your trust and get them recorded in whatever place that is. Doesn't matter where it is. But yes.
Is having someone articulate on video what their wishes are valid? Additionally, is it recommended in lieu of a will?
You could probably have a video recording that you would have witnesses at, and probably somebody to verify their capacity. And that recording potentially could become an authenticated document, but you would need to meet all of the requirements of a will. Presumably somebody would take those recordings and draft them up and have it signed. But I mean, the concern I have is with the technology that we have, if that recording is not clear and half of it's missing or chopped up, you don't really have a complete document. That would be my concern. I would still want it signed off on, notarized, with all of the requirements of witnesses, etc.
So we have one question from St. Croix, and then we're going to ask all the attorneys to sit on the panel so we can do general questions for the next 10 minutes because we are now over the 8 o'clock hour. But we do have one last question on trust from the island of St. Croix.
Yes. What makes a trust valid? What validates a trust? And is it filed anywhere?
There's no filing requirement. What I tell people is, at least for the trusts that I've created, there's a lot of confidential information in those documents, and it's not a matter of public record. I have a different take from some of the other attorneys in terms of what you want your beneficiaries to know. I've unfortunately had experiences where people literally have tried to get the grantor to change things and write people out and put other people in and do some crazy stuff. So my take on that concept, at least as far as a trust is concerned, is if you don't know what you're getting, you're not going to try to lose something. You may be better off leaving it alone. With respect to what is required in a trust, the trust has to be drafted by the settler, and if they are the trustee, they would identify themselves as the first trustee and then identify the other people that are the successor trustees. It has to be signed, witnessed, does not have to be notarized. If you want it to be notarized, it can. It does not get recorded. I have seen some people do that, and I shake my head wondering why anybody would put all of that information on a public record.
Okay.
What I
would
recommend
like to
is that
invite all the attorneys to the table so that we can ask general questions for the next 10 minutes. We're going to have a speed round. You're moving cameras. St. Thomas needs to move their camera to the table. And we have Attorney Ballantyne and Attorney Paiwanski in St. Thomas. And I know there's some burning questions to ask questions. Make sure for those that are leaving that you fill out the estate planning conference exit survey, please. It's really important to us to make determinations as you're walking out. But here's the first question from St. Croix.
Thank you. Hi, good evening. Quick question. Is the transfer on deed, is that applicable only to Virgin Islands, or is that applicable statewide as well?
The answer is that it would. Can you hear me? Yeah.
Yes.
The answer is that it would depend on the statutes in the other states. So the TOD statute in the Virgin Islands applies to Virgin Islands real property and Virgin Islands vehicles. If you have property located in another state, it would depend on whether that state allows a TOD deed or not. So if you have property in Michigan, it would depend on what the law is in the state of Michigan.
Okay. From the island of St. Thomas.
Hello?
Any questions?
Yeah, we have a question.
Okay, please go ahead.
Good evening. Can you hear me? Yes. Okay, I have a question for the benefit of the audience. Can you explain what a probate without administration is, and in what situations would a court more likely allow it or not?
I'll start on this one. A probate without administration is an expedited probate process in where basically you don't have to file a notice to creditors. It shaves about 6 months off the probate process, but those beneficiaries or heirs that take a distribution pursuant to the final accounting have to sign off that they're subject to any creditors' claims, since creditors were not notified. So it depends on whether you want to go through that process to clear up creditors' claims or take the property subject to creditors' claims.
Okay, we have a question in St. Croix.
Good evening. My question is, when is a trust required to file a tax return?
So most people, again, this is an accounting, you talk to your accountant about this. There's two options. One option is that during your lifetime, you can have the trust use your Social Security number. A lot of times I've seen accountants file the return under the individual until they die, and then upon their death, they get an EIN number for the trust, and then the trust files. I've seen scenarios where the trust during your lifetime files. I've seen scenarios where you individually file with something on your tax return that refers to the trust, and I've seen scenarios where the trust itself is filing with its own EIN number. This is an accounting CPA question as to which category you're going to fall under. But one thing that is guaranteed is after you pass, the trust has to have an EIN number and then would file a return under that EIN number.
Attorney Ballantyne, you spoke about ideas of things that we have to remember. One of the things that we hear about a lot is forgetting to take ex-spouses off of a beneficiary receipt. Could you speak a little bit about that, please?
Well, I haven't had that experience but if the person is named as a beneficiary, that person is who will get whatever it is they're named for. So it is important that you keep up to date on everything in terms of the changes, not only in terms of your assets, but changes in your own life. So if you have an ex-spouse, And you want to make sure that they're off of all of your accounts, your insurance policies, your health insurance, unless you have a divorce decree or something that says they have to keep them on there. But other than that, you want to make sure that you're changed to reflect your current state of affairs.
Thank you. There's a question over here. Hold on.
Beneficiary under 18? Can you hear me? Beneficiary, if you have a child that's under the age of 18, should you make them your beneficiary? Should you list them as your beneficiary?
You can list them as a beneficiary. You mean like if you had several beneficiaries, you can list them as a beneficiary. I think the concern, you may want to have a situation where you have someone as their guardian until they reach the age of 18 or something to that effect, so that in the eventuality that you may pass before they reach 18.
Okay, good evening.
We have a question from St. Louis.
Okay, thank you. Regarding administrators, executors, when they're doing their assets and their detailed report on the debts and the balance, is there a timeline when they have to provide that information to the heirs or beneficiaries? And two, when does the executor administrator, when they share the inheritance to, like, if there's more than one, 5 or 7, whatever, do they share what each individual receives? Or is it just per?
So once the administrator or executor is appointed by the judge as the executor or administrator of the estate, then basically they have to produce a quarterly accounting every 3 months. That quarterly accounting is submitted to the court, and it has to be copied to all heirs or beneficiaries. So pretty much it's an immediate accounting responsibility, and it's distributed to the court and to all of the ultimate heirs and beneficiaries. Likewise, when the probate proceeds to a final accounting, the final accounting presents the total amount of the assets and the proposed distribution to every one of the heirs or beneficiaries. That is distributed to, that proposed distribution is sent to all the heirs or beneficiaries, and they must sign a waiver of any objection and consent to their proposed distribution in order to get the distribution signed off by the judge. If anyone does not sign the waiver and consent, then the court will conduct a evidentiary hearing, and those beneficiaries or heirs that did not sign the waiver and consent will be allowed to appear and propose or propound their objections. So that's how it goes.
Okay, we're going to take a question from St. Croix and then one from St. Thomas, and then we have people online still with questions. So, St. Thomas?
Question over here.
Hi, good evening. My question was, what's the average cost of a trust? The average cost of a trust.
Okay, that's a difficult question to ask, and what I normally tell people is if you go into an attorney's office and based on the value of your estate, they tell you how much it's going to cost, run to the exit. Having said that, most of the time what increases the cost of the trust is the amount of things that need to be transferred. If you have 2 pieces of property being transferred to the trust, it's going to obviously cost less than if you have 10 pieces of property transferred to the trust. So it is a factor of how much documentation has to be created to effectuate the transfer, but the trust itself probably ranges between $2,000 and $5,000, depending on what it is that you're putting into it. But the thing I can't stress enough is, if you go into an attorney's office and you've got a piece of property that's worth a couple $1 million and they base the price on the value of your property, that's not the mechanism that determines what it costs.
Okay, a question from St. Croix.
Tony Scott Machine, will challenge. How does it work? For instance, if somebody has like 2 or 3 kids and they have a will, and one of them are willing to challenge the will, how does that work?
Basically, the disgruntled heir or beneficiary would file a notice of will challenge with the court, and they would explain what their challenge is. They may state that their parents had been deceased at the time that this alleged will was forged. They may say that they were incapacitated mentally or physically at the time, thus it must have been forged. Or they may say that during some period of incapacity, there was undue influence by another relative, which resulted in a more favorable distribution to that heir or beneficiary. Those are the standard will contests I've seen. After the will contest is filed, there's usually an opposition from the executor supporting the validity of the current will. Oftentimes then there's an evidentiary hearing scheduled before the court, and there will be a process by which the parties are allowed to engage in discovery, issue subpoenas, try to determine the validity of each side's allegations. Then witnesses and evidence will be presented at an evidentiary hearing, and the judge will ultimately make a ruling on whether they find the propounded will to be valid or whether they accept the will challenge and believe that the will challenge was supported and that the will presented was invalid. That's, again, going to be a lengthy process. You're probably looking, one, at the motion practice, then you're looking at an evidentiary hearing, then you're looking at a discovery period to gather the evidence, and then a presentation to the court at a rather lengthy evidentiary hearing, and then a period of time for the court to digest all the evidence and make a ruling based on the facts and the law.
Thank you. We have another question, and then we'll go back to St. Thomas. Hold on.
Hi, good evening. I have a question. I was involved in an accident at one point, and the person who owned the vehicle was coming after my assets. Can I ask why he was so eager?
I'll just ask, are there pros and cons to consider when determining the jurisdiction you want to establish your trust in? Does that matter?
Trust.
So you suggest establishing a trust wherever you decide.
Nadine, you can hear me?
We can now hear, but we couldn't hear before.
So you want a question on St. Thomas?
Oh, you have a question on St. Thomas? You just ask a question on St. Croix, and then we'll go to St. Thomas. Actually, a question online. At what age should you consider having a will or a trust?
Thank you very much, ladies.
At what age? We can't hear you. Start to take St. Thomas. Can we hear St. Thomas? Let me speak, please. 30 seconds left, 3 minutes. Hello, St. Thomas.
Hello? Yes, we have questions.
Okay, so wait, we have a question online. Ask the question again.
At what age should someone start a will or a trust?
If you have something of value, you could start one at any age. If you're a teenage millionaire, I would suggest you have something.
Okay, we're going to go to St. Thomas because there's a question on St. Thomas and then come back to St.